Hello everyone, so this is our third video of polity and we are going to discuss the fundamental rights. Okay, so before starting the study of fundamental rights, it is important to study or know something about rights in itself. In the old regime, the king ruled by despotism. What is the meaning of despotism? That whatever the king wished, that was the law of the land. So this was going on, and then what happened in 1215? Something happened which is called Magna Carta. So actually, a very unpopular ruler of England, King John, he became the king of England, and because many people were not happy with his conducts, he used to illegally prosecute and imprison. So the barons wanted to protect their rights, liberty and freedom. Magna Carta is the royal charter of rights agreed by King John of England on 15th June 1215. It was drafted to make a peace between the unpopular king and a group of rebel barons. It promised the protection of the church rights, protection for the barons from illegal imprisonment, access to swift justice, and limitation on feudal payments to the crown, to be implemented through a council of 25 barons. So this was first charter of rights, we can say. It was published in 1215. And then we have something called natural rights, legal rights, and so on. So what happened? During the old regime, we didn't have much concept of rights, but when the old regime will wither away during the French Revolution, then the philosophers, they will come forward with concept of natural rights. So the philosophers will give the concept of an alternative society. They will say, no, there is nothing called divine theory of kingship. Rather, each and every individual is endowed with some of the unalienable rights, and they are called natural rights. If you will read the preamble of the US Constitution, which we did in the last class, there it was written that it is to be self-evident that all men are born equal and they are provided with inalienable rights of freedom, liberty and pursuit of happiness. So there are certain rights which no one can take from you. So natural rights are those that are not dependent on the law or custom of a particular culture or government, and so are universal, fundamental and inalienable. They cannot be repealed by human laws, though one can forfeit their enjoyment through one's action, such as by violating someone else's right. For example, if somebody kills someone, then we sentence that person to death. Although right to life is a natural right, we should not be killing someone. But if he kills someone, actually taking away the natural right of some other person, in that case, to civilize the society, we can punish him. Then what are legal rights? Legal rights are those bestowed onto a person by a given legal system. They can be modified, repealed, and restrained by human laws. For example, right to privacy was modified and made into fundamental rights. Then Section 377, that was repealed, and then there are some provisions which are restrained by human laws. For example, during emergency, we have certain provisions which are restrained. The concept of positive law is related to the concept of legal rights. So we have these legal rights to make society progressive, to make it a welfare society. During the age of enlightenment, the concept of natural laws was used to challenge the divine rights of king, which I told earlier, and became an alternative justification for the establishment of a social contract, positive law and government, and thus legal rights. The idea of human rights derives from theory of natural rights. So the idea of human right, which we are going to see afterwards, the UN Declaration of Human Rights, which is quite important, derives its theory from natural rights. So now we are going to study the part 3 of the Constitution, which extends from Article 12 to 35, and this part is called fundamental rights. So if a question comes, the part 3 of the Constitution is related to the fundamental rights. Okay, before we start, it is important to know part 3 of the Constitution provides for justiciable fundamental rights. They are justiciable, means if someone is violating your fundamental rights, you can directly move to the court, to the Supreme Court even. These fundamental rights are protected against invasion of the executive, legislature and judiciary. Some of the fundamental rights are negative rights. So what does it mean? It basically restricts the government to make a law, have a provision which is against those particular rights. Then they are inspired from the Bill of Rights of the USA. This is also important. A direct question can come. Fundamental rights have been inspired from the Bill of Rights of USA. The right to property was deleted from the list of fundamental rights by the 44th Amendment Act of 1978. Now come to this. Before we start our study of fundamental rights, it is important to define state and define what is law under Part 3 of the Constitution. So if a question comes, what does Article 12 do? Article 12 basically deals with the definition of the state, which includes the government and the parliament of India and the government and the legislature of each of the state and all local or other authorities within the territory of India or under the control of the government of India. They are called state under this particular part. Now come to Article 13. It defines laws. For example, any pre-independent law which is against the fundamental right will not be called law at all. That will become null and void. Then second one says, the state shall not make a law which is against the provision of fundamental rights. Suppose the state has made some law which is against the fundamental right. Then the judiciary will decide whether or not it is against the fundamental rights. If it is against, then that will be struck down and it will again become null and void. So this particular thing is called judicial review, that the law is reviewed by judiciary to check whether it is against fundamental rights or not. Then laws included in ordinance or the rule, regulations, notification having in territory of India the force of law. So that is also called law. So here you can see ordinance. So an ordinance is made by executive, but it is considered a law. Then number 4 is very important. Nothing in this article shall apply to any amendment of the Constitution made under Article 368. Article 368 talks about amendment. So you have 73rd and 74th amendment which are quite popular. Similarly, you have many amendments. So amendments are not considered a law under this particular part of the Constitution. This is important. Now come to fundamental rights. These fundamental rights are protected against the invasion of the executive, legislature and judiciary. The Constitution guarantees 6 types of fundamental rights. The first one is right to equality. The second one is right to freedom. Then we have right against exploitation, right of freedom of religion, cultural and educational right, and lastly we have right to constitutional remedies. Okay, now the first one, right to equality, that starts from Article 14 and goes till Article 18. Now Article 14 says the state shall not deny to any person equality before law or the equal protection of laws within the territory of India. So what is supreme in India? See, a person or a despot or a ruler is not supreme. What is supreme? Law is supreme. So each and every individual, each and every citizen will be equal before the law, and all the laws will be protected by the Constitution. This is the meaning of this, and this is the meaning of Article 14. So the concept of rule of law, which is an important concept and was given by TISS, has been enshrined in the Article 14 of the Constitution. Then you had a film by the name Article 15, in which you had Ayushman Khurrana. You can make an imagery out of it and then try to remember. The state shall not discriminate against any citizen on the grounds only of religion, race, caste, sex, place of birth, or one of them. That means on 5 categories. Apart from these 5 categories, the state can discriminate. but they will not discriminate on the basis of religion, race, caste, sex, place of birth. So there are 5 categories. You should remember 2 are R, that is religion and race, and then you have caste and sex, then place of birth. Now come to Article 16. It says no citizen shall, on ground only of religion, race, caste, sex, place of birth, and 2 more will be added here, descent and residence, will be discriminated against any employment. So while making a public employment, you can't discriminate on the basis of religion, race, caste, sex, place of birth, and descent and residence only. Now there is a lot of states like Goa, then MP and Haryana, they have provided 75% reservation for the locals. So is it allowed? So basically this particular article, Article 16, talks about public employment or employment by the state. It does not talks about private employment. So that is why that is not an infringement of Article 16. Now come to Article 17. It states untouchability is abolished and its practice in any form is forbidden. In any form means in whatever forms untouchability is practiced, it is forbidden. For example, this Sabrimala judgment, not letting a woman go in the shrine, is a type of untouchability which the Supreme Court said in the verdict, and that is why it was struck down. The enforcement of any disability arising out of untouchability shall be an offence punishable in accordance with the law, and this is an example of only absolute right where you don't have any reasonable restrictions. Then we have Article 18, which is also right to equality. It says no title not being a military or academic distinction will be conferred by the state. No citizen of India shall accept any title from any foreign state. So the foreign spelling is wrong, it should be N not H. Any foreign state will not confer any title to a particular citizen of India. So here there is a confusion between awards and title. So the Bharat Ratna and Padma awards are not titles and cannot be used as prefix or suffix to name, and they can be withdrawn by government in case of misuse. The Bharat Ratna and Padma awards are not titles, number 1. This is very important to understand, and that is why Padma Shri Kangana Ranaut, that is not allowed. There are a lot of jokes on social media about that, so I gave that example. That is not allowed. Now our PM, he gets a lot of awards in many countries. Those awards are not titles, they are awards which is allowed. There was talk about giving Sir title to Sachin, like Sir Don Bradman, Sir Sachin Tendulkar, but it was not allowed, or it is not allowed in India to do so. That is why he didn't took such title. So we talked about Article 14, which says equality before law and equal protection of laws. Then Article 15 talks about non-discrimination on 5 bases of religion, race, caste, sex and place of birth. And then you will add 2 more, that is descent and residence. Then it will become Article 16, and Article 16 is for employment, public employment. And then Article 17 talks about banning untouchability, and 18 talks about not having titles. So these were the fundamental rights of, you can say, equality. So in our next video we are going to see very important fundamental right, that is fundamental right of freedom, where we'll see Article 19, Article 21, which are very important. Okay, so this was all for today. Thank you. Thanks for watching.